I'm Joan Blum. I don't have a PowerPoint or anything, but I do have a handout up here. If you don't have the handout, please go pick it up, because what I'm going to show up there is the handout, and even easier for you to follow along. Let me just give you the context of these two assignments. These are two assignments that occur in my first year legal writing course. During the time, immediately after the students have handed in their first graded draft memo assignment, and I am spending a great deal of time grading 45 10-page memos, and I need something to do with students and classes during that time. Traditionally, in our legal writing program, we have used this time as an opportunity to teach further research skills, which most of us do during this time. But I've kind of got this practice-ready bug, and started looking through my own personal experiences and skills to see if I had something of value that I could add to my curriculum. My own personal practice background at Yates many years ago was as a bond lawyer. So I did a lot of transactions, a lot of drafting. Over the years, I taught a legal drafting course. And I said, well, maybe I just want to expose my students, not teach them how to draft a contract, but show them that contract drafting is something that lawyers do, and that they are in a position to draft a provision of a contract, having just finished researching a contract problem. Okay? So the problem that my students have just completed, this is, say, mid-October, and the students have just handed in the graded draft of a New Jersey covenant not to compete problem, which focuses them on the public interest part of the test for enforceability of covenants not to compete. And we go into class the first day. Actually, it is the day they handed in. It is the day they uploaded. And so they're really wondering what's going to happen in class. What am I going to do? Have I already graded them all? You know, it's 10:45, and they uploaded them at 8:45. What have I done? So they come into class, and I say, well, what we're going to do is we're going to build on the skills that you have developed in doing research and analysis to draft part of an employment contract. And let me go on to my next page here. And I do a very, very short lecture. This, the basics, comes, I see a couple of my former students in this room, and I don't think I did this problem with you guys, but in the intervening years, I did have a long and involved PowerPoint on drafting operative legal instruments, and I did that kind of later in the year. And I felt that that really bombed. I mean, that was not something that I wanted to continue doing, but I wanted to use my expertise in this area to expose our students. And students in the spring semester have an elective that they get to choose. One of those electives is advanced contracts, in which they do a lot of drafting. So I wanted to put these students in a position of saying, maybe I like doing this. Maybe I want to take that instead of employment law, tax law, labor law, and other things that they're being offered in the spring semester as an elective. So I just had a lecture. I said, well, this is basically it. Lawyers draft contracts. You are often, if you have a general practice, you would be asked upon to draft a contract. If you're a litigator, you probably be drafting settlement agreements. If you are not a litigator, you will be drafting different sorts of, maybe very complex agreements. And this is just one piece of an agreement. But the same rules apply. In order to draft a contract, you have to know the transaction. Knowing the transaction means understanding the facts and understanding the law. Right then and there, I really was a bit surprised. Like, what is the relationship of law to contracts? Where does that come in? And many of them have signed contracts, but they've really not thought that there is law underlying those contracts. That know this law called? They have just this month. Researching and writing a substantial memo, and they really know the New Jersey law of post-employment covenants not to compete. Then I tell them from my great experience as a practicing lawyer, I usually start drafting from scratch. It's really important to locate a model. We talk about where do models come from. Models can come from form books, and they can be useful. Models can come from your own previous transactions, and models can come from other people in your practice environment. So we talk about getting models. But it's not a good idea to start drafting from scratch. So if this is not a completely novel agreement, and most agreements are not completely novel. Finally, we talk about modifying the model. That you have to be sure you have a good model, and you have to make sure you understand the law, so that you can understand how to modify the model to make sure that the model fits not only the transaction, but fits the law of the jurisdiction you are in. So for example, in California, post-employment covenants not to compete are generally prohibited by statute. Okay? In New Jersey, they're not. You would not want to use a New Jersey model for a California client. Very simple, but a very important piece of information for students to understand the federal system. Okay? Okay. So that's kind of the law part. Then we talk about the writing part. Use ordinary language and precise punctuation. Use ordinary language is probably the most important part of that. Many, many, many years ago, I think it was my first year of teaching, I went to a conference at University of Indiana in Bloomington, headed by Reed Dickerson, who was a pioneer in bringing legal drafting to the large classroom. And of course, that was the day before projectors and computers, and he did it by doing drafting with overheads. And he would have the students, he had something like 90 students in a class, he'd give the assignment, and he would respond to those assignments not individually, but through marking up overheads in the classroom. And that's kind of the principle that I use for this assignment, although I ask students to send me their samples, and I mark them up with the students. We discuss them in sort of a fishbowl way in class. It is possible to be exposed to legal drafting in this way. It may not be possible to develop an expertise without individual critique. But it is possible to get that exposure, and that's really what I feel is my job in the first year. To get the students interested in it, to get the students to see this is what a lawyer might do, and then to follow up on opportunities following my class. Okay, so the practice problem, now that you've got the background, the practice problem is pretty simple. This is a different version of the problem that our students, my students, have just submitted. I don't feel like they're in the mood having just handed in a paper on a particular fact pattern to draft a contract for that fact pattern. So I think of a different fact pattern, and what this reinforces is that expertise is transferable, so that the students, having researched one covenant not to compete problem, know how to draft another covenant not to compete problem. And I tell them, yeah, you may have to do some additional research because different facts raise different issues, but you basically understand how to approach this. And so these are the facts. And then I leave, I have this on the screen with the students when I'm doing this problem with them, and I leave space for additional facts. If students have additional factual questions that would help them do this drafting project, I'll take them and answer them. This is an ungraded assignment. All of it occurs in one full class and then part of another class. So it's one 75-minute class, followed by about 15 to 20 minutes of a second class. There is no out-of-class activity for the students unless they get really fired up and they want to redraft it after class. And I did have some people with that problem. So then, at this point, I tell them, you're the expert on the law of covenants not to compete in New Jersey. You know what the law is. Here's a couple of models that I found. One from a form book, one from a previous matter. And then I just say, go for it. You know, just go for it. And I give them about 20 minutes to do some drafting. And they do it alone. I don't have them do it in groups. I thought about possibly having them do it in groups. But the first time you do something, I think it's a good idea to confront your fears on your own, and only after that collaborate with other students. And then I know my students, and I have 45 of them, so it's a big group. You know, it's a big sample, and I kind of know that somebody is going to want to volunteer. And there's always one. And I had a volunteer, and she sent me a decent sample. And it was pretty much this one. And then we spend the rest of class discussing the same. And I highlight things. This was not exactly what I used in class, but I just wanted to give you a sense of how I responded to the student at the moment. But I only got one sample in class. And then the 75-minute class was over. And I said, look, I'm not requiring you to continue with this exercise. This is an in-class exercise. You worked hard enough. You just handed in that big paper. But if there's anybody who wants to continue with this and email it to me, I'd be happy to see it. And I did get more than two, I think. I've got given you two here. But I got several, and I did hear anecdotally from the students that they loved this assignment. First of all, it didn't require them to do anything out of class because they were exhausted. Second of all, it gave them a look at memory that they had not yet had in the first year. They could also see that research, which is one of my great loves, has applications beyond the litigation context. So for that purpose, for all those purposes, this I felt was a successful assignment. How would I change it? I have not really given that a lot of thought for now. I think I'm going to reuse this as it is next year because it was a very successful assignment. But if anybody has ideas and would like to email them to me about how this might be improved, I would most certainly love to have them. And I think I have my email address on the front. I do indeed. Okay, so I would be very happy to have any suggestions that you'd want to give me about improving this assignment. Okay. Okay. I have till 1:45, right? The second assignment I've given you takes place in also this interim time between students handing in their draft, getting the draft back with comments so that they can improve on it for their final memo. I have traditionally used this part of the course to introduce my students to statutory research. I don't use a statutory problem until the spring semester. But this seems to be the right time to do it in the course because there's enough time to spend on statutes. So the problem I face is how do I consolidate their research skills without having them apply those skills directly into a problem. So my idea was make up a problem, but that would mean I'm running two problems at the same time, you know, and I'm running this covenant not to compete problem, which I'm grading and the students are going to have to rewrite, and now I'm introducing a new statutory regulatory problem. I decided that the way to do that is to make the writing product very different and much less time-consuming for the students. So I developed this problem. It's an immigration law problem. It requires the students to locate statutes, locate federal regulations, and apply the statutes and regulations to a fairly simple fact pattern, and the written product that consolidates all their work is not a memo, but an email. How can I get away with not having the students do their analysis in a memo or sending an email? Well, there are really no applicable cases. There are cases in the annotations to the statute, but they don't really address this problem. So we were talking about this at dinner last night, Emily. This is an opportunity for the students to see that not every problem has relevant cases. So what I have the students do is, it is kind of a complicated problem sequence. I have a teaching assistant and a couple of research assistants, and what I have them do is divide my students into groups of 5, take them into the law library, and introduce them to print statutes. Then we teach them how to do statutory research and federal regulatory research online. Then I give them this problem, and they do the research pretty effectively. I really want them to remember how you locate a statute. I want them to remember how an annotated code is set up. I want them to understand the relationship between a statute and regulation. And I want them to understand the relationship between regulations and agency websites. So those are the things I want my students to learn. And the writing is basically just a way to get them to focus. And focus they did. I got a bunch of emails. This was not an in-class assignment. This was an out-of-class assignment. I felt that this came the following week, so I felt that they had recovered enough from their memo to be able to ask them to do some homework. I got a bunch of really good sample memos, emails. I did, Mary, give them directions, kind of similar to the directions that you give them to make sure that they are professional emails. Although I didn't talk about sections of an email. Since this was the first year I taught emailing, I think I'm very happy to be at this conference because it has given me some ideas about how I could change this project to focus a little bit more on the writing and a little bit less on the analysis and research. Or perhaps to capitalize more on the analysis and the research to have a writing project. And there is really no reason why this project, this writing project, had to be directed to a work supervisor. This could be directed to a client. Many immigration lawyers practice in small firms. They don't have a supervisor to send an email to. They communicate with their clients frequently by email. And so at this moment, I am actually flowing over into the client letter camp because I think it is a really good idea to give the students an opportunity to write to someone other than a supervisor or a judge during the required first year legal writing course. But they have really strong directions, and I did get some emails that started out saying, I hope you had a lovely weekend. And I did not validate that. I said that this is going to go into a file, and someone's going to look at this, possibly in 1 year, 2 years, 5 years, and it is really irrelevant to be talking about what. This is a professional communication. It should be written as a professional communication. Some of my colleagues, actually, with whom I discussed this with, felt that I was a little too harsh on it. But that's the position that I believe is appropriate to take, and so I'm going to stick with that. What I did find in the emails, and this was a particularly good one, this was from, these were not submitted anonymously, so I know the student from whom this email came, and he had worked as a paralegal for 4 years in a big New York law firm. And you can really tell that he had been trained to write an email. And that's why I'm glad it's not a graded assignment. But he really came up with a very nice analysis, a very nice organization, background, analysis. He divided things up with headings. just did an excellent job on this email. I showed this to the students, to the other students in the class as an example. I did not say who it came from. I did not say that the person had a lot of training before law school. But the students were very happy to have this because they felt that this assignment had opened them up to a form of writing, the formal email, that they had not even thought existed. And as students move on from the first part of the first year to the latter part of the first year, when they're looking for summer jobs, they are very happy to have models for writing. And a number of students told me, oh, this was a lot of work. They wish it had been graded because they thought they did a good job. But even though it's not graded, they're very happy to have it. And I was very happy to do it. And so I think that what I will do in the future is take some of the suggestions that I heard from my colleagues on the panel today and incorporate them into this assignment to improve it. And again, if you have any suggestions about how I can improve this assignment, I would love to have them by email. I did want to take one more minute to say that I had the students find the form that needs to be filled out on the USCIS website, and I had them look at the form so that they can understand that. Open up. Okay, so I had them look at the form. I would love to make this a longer simulation to have them actually fill out the form. This is what lawyers do. My husband's an immigration lawyer. This is every day. But I didn't have time to do that in the simulation. The last thing I wanted to make sure my students knew was before you fill out any form, see if there are instructions. And so this was included in the materials on my course website. So I felt that this gave my students kind of a nodding introduction. These two assignments in summary were both nodding introductions to things that the students just might not pick up in the first year. Actually, some might not pick up in the second year as well. These are very useful things to have in their professional baggage.